Finality C. Start. The appellants before this court who were applicants before the tribunal original numbered 5. However, the fourth applicant before the tribunal has not approached this court. Therefore, these appeals are instituted by applicant numbers 1, 2, 3 and 5 only. The sole appellant in SLP number 5580/2024 was applicant number 2 before the tribunal, whereas the applicant number 1, 2 and 3 in SLP number 11086/2024 were applicant numbers 1, 3 and 5 respectively before the tribunal. For ease of reference and to maintain consistency, they shall continue to be referred to by their original applicant numbers as before the tribunal. The appellants before this court being applicant numbers 1, 2, 3 and 5 before the tribunal were originally engaged by the Central Water Commission on part-time ad hoc terms. Applicant numbers 1 was appointed as a Safai Wali in 1993, applicant number 2 as a Safai Wali in 1998 and applicant number 3 as a Safai Wali in 1999. All three were primarily responsible for cleaning and maintaining the office premises under the CWC. Applicant number 5 appointed in 2004 as a Khalasi, also discharging these duties akin to a Mali Khalasi, was entrusted with tasks such as gardening, dusting and other ancillary maintenance work. Throughout their engagement, these individuals performed essential housekeeping and support functions at CWC establishments, including its office at Faridabad, ensuring daily upkeep and contributing to the smooth functioning of the Commission's administrative operations. Initially, the appellants sought regularization of their services by filing original application before the tribunal. They contended that over the years their roles and responsibilities had evolved beyond the nominal levels of part-time or contractual and that they were performing ongoing and core functions integral to the CWC's operations. They relied on applicable government instructions and the principle that long-serving employees engaged against work of a perennial nature deserve fair consideration for regularization, provided their appointments were not illegal or the tribunal by its order dated 17/4/2018 dismissed the appellant's plea. It concluded that the appellants were not engaged on what it considered regular vacancies, that they had not completed what it terms as sufficient full-time service, and that their case did not attract the principles enabling regularization. Within 10 days after the dismissal of the original application, the services of all these individuals were arbitrarily terminated by the respondent authorities without issuance of any show cause notice. Aggrieved by the tribunal's decision and subsequent termination, the appellants approached the High Court. They urged the High Court to recognize their long and continuous service, the nature of their work, and the lack of any backdoor or illegal entry. They highlighted that they had functioned without any break, performed tasks equivalent to regular employees and had been assigned duties essential to the regular upkeep, cleanliness, and maintenance of the respondent's office. The High Court, after examining the tribunal's decision and the submissions advanced, concluded that the petitioners before it were part-time workers who had not been appointed against sanctioned posts, nor had they performed a sufficient duration of full-time service to satisfy the criteria for regularization. It relied on the principle laid down in Secretary State of Karnataka versus Uma Devi, holding that the petitioners could not claim a vested right to be absorbed or regularized without fulfilling the requisite conditions. The High Court further observed that the petitioners did not possess the minimum educational qualifications ordinarily required for regular appointments, and additionally noted that the employer had subsequently outsourced the relevant housekeeping and maintenance activities. Concluding that there was no legal basis to grant the reliefs sought, the High Court dismissed the writ petition. Aggrieved by this rejection, the appellants have approached this court by way of these appeals. On behalf of the appellants, the following arguments have been advanced before us. Continuous and substantive engagement. The appellants emphasized their long uninterrupted service spanning well over a decade and in some instances exceeding 2 decades. They argue that their duties were neither sporadic nor project based but permanent and integral to the daily functioning of the respondent's office staff.